Okay, I'm going to go ahead and get started. Let me see if I can pull up what I need to pull up. Okay, as I said, I'm going to go ahead and get started. This is going to be a fairly lengthy one today, a lot longer than our normal ones. So, what we're going to do is I'm going to begin the class today by reviewing the exam number one, and then I'm going to move to exam number two, the one you took yesterday. And after I have concluded those, I will go into a preview or some tips, some things I think you need to cover for sure in the torts exam for next week. And then after I conclude that, we'll go ahead and go to the following week's materials on consumer protection. So let me go ahead and get started. I'm going to share my screen with you. It may or may not come out on your screen very well, but you can probably follow it decently. At least it helps me to stay on track. Courts and alternative dispute resolution. Some of you learned the hard way that material that I provide for you, even if short, is number one, important. Number two, can give you a whole lot of questions. And and my handout on Alabama state courts certainly provided that. There was a lot of questions related to that. Anything is fair game, and anything in the material is fair game. And as I've said before, there's no homework for this class, but there's a lot of reading. You have to read everything, unless I tell you it's not important, in which case, why would I have prepared it in the first place? So, without further ado, Fred, an Alabama resident, is injured in a motor vehicle accident. There's only state law causes of action. That tells you right away there's no federal jurisdiction, no federal question jurisdiction. Still might be federal diversity jurisdiction because it can hear cases involving state law causes of action, but you got to meet the diversity requirements. He sues Frida, who's a Mississippi citizen, for $90,000. Where can he file suit? Well, that one satisfies federal diversity because it's over $75,000 and the plaintiff is diverse in citizenship from the defendant. That's all you need for federal court jurisdiction. For state jurisdiction, well, state district court can hear state cases up to $20,000. So this exceeds $20,000, so it can't be state district court. So the only answer here that's correct is the last one, Alabama State Circuit Court and U.S. Federal Court. And this is typical of the type of question that I'm going to be asking all semester long. It's going to be something that is going to require you to dig through, to review, to think about how the different things are analyzed and to apply the law. Second question, state district court has exclusive jurisdiction over civil claims over $20,000. Nope, under 20. And it's not exclusive even then. So there's a lot of reasons that's false. Question three, a federal district court in Alabama must treat a 1985 decision from the Fifth Circuit as binding precedent if the 11th Circuit has not addressed the identical legal issue. This is a question that tripped up a lot of students, but it shouldn't because only pre-1981 decisions are binding. After 1981, we had our own circuit. After that, the Fifth Circuit doesn't really matter anymore. for decisions after 1981, after we created our own circuit. Now, before 1981, it's binding if the 11th Circuit hasn't ruled, but after 1981, it's not. You don't treat it that way at all. Okay, next. If a defendant in an Alabama State Circuit Court fails to answer within 21 days, plaintiff can immediately seek a default judgment. False. They've got 30 days to answer in State Circuit Court. Question 5, probate courts in Alabama exercise general jurisdiction. No, they don't. It's a court of limited jurisdiction. That tells you it's false right away. 6, for a lawsuit involving $5,500 in unpaid services under state law between two Alabama citizens. So state law, no federal question jurisdiction. It's only $5,500, so you know there's no federal diversity jurisdiction because you got to be over $75,000. So it's a state law case. It must exclusively be filed in the small claims division of state district court, and that's true. Up to $6,000, small claims division of district court has exclusive jurisdiction. Nobody else. After $6,000, it's concurrent with state circuit court. Question 7, in federal court, a default judgment against the United States government can be requested after 30 days if no answer is filed. That's false. It's got to be 60. 8, venue determines a court's power to adjudicate a case, while jurisdiction refers to the appropriate geographic location for trial. That's false. And the reason that's false, it's exactly the opposite. I gave you the right definitions, but for the wrong words. Jurisdiction determines the court's power. Venue is the most appropriate geographic location. 9, a non-party witness can provide sworn testimony in a deposition, but only if they have a direct financial interest in the lawsuit's outcome. That's false. Nothing I gave you said anything like that, and that's not accurate. 10, Alabama Court of U.S. Civil Appeals is the court of last resort for civil matters in the state. I have no idea what that is, but it's Supreme Court, so the answer there is false. State Supreme Court. 11, federal courts have concurrent jurisdiction with Alabama state courts over claims arising under federal statutes like the Fair Debt Collection Practices Act, even if the amount in controversy is below $75,000. That's true. State court can hear it, but so can federal court because it's a federal question. It doesn't have to be over $75,000 if it's a federal question. 12, Lila, an Alabama resident, sues her Florida-based employer for $80,000 in unpaid wages under state contract law. She wants to file in federal court. She really should have considered the Federal Fair Labor Standards Act, but she didn't. She wants to sue in state contract law. What must she establish for diversity jurisdiction? Well, so I'm asking you, what requires for diversity? Well, we've got a plaintiff that's from Alabama, defendants in Florida, amounts over $75,000. So she's got it. And the second answer is the one that you look for. Complete diversity of citizenship between parties. Yeah. And an amount exceeding $75,000. Yep. She meets both of them, so she can do what she wants to do. 13, in a discrimination lawsuit filed in Alabama federal court, the 11th Circuit lacks precedent, but a 1999 circuit ruling, should have said a 1999 Fifth Circuit ruling, favors the plaintiff. How could should the district judge handle this? The judge may consider it persuasive, but is not required to follow it. I know what it's supposed to say. There's a typo there, and it should have said the Ninth Circuit, a Ninth Circuit Court of Appeal ruling. I'm going to give everybody 6 more points, not just the people that are here, but everybody in the class. I'm going to give you 6 more points because that's my error. That's a typo, and it made it very difficult to read. I'm not going to assume that. I'm going to look, even if you got it right. I'm just going to give everybody 6 points. So there you go. So whatever you thought your grade is, it's six more points on top of it. Okay. 14, Marcus is sued in Alabama District Court for $12,000. let me take that back. I may take a look at it and see if I can. Well, I said I'll give you the 6 points, so I'm gonna give you 6 points. Okay, Marcus is sued in Alabama District Court for 12 grand in property damage. He ignores the complaint. How many days expire? Can he typically move for default judgment? Answer is 14 days. 15, what scenario correctly demonstrates a lack of standing? A taxpayer files suit against the government over a policy that indirectly raises their taxes by $50. Everything else, you've got a direct injury. That's what standing is. You have to be the one that suffers the harm directly. Taxpayer derivative lawsuit, if it's indirect, well, that's you don't have standing for that. So that's the best one. Everything else is direct. Discrimination against the employee. Company sues for breach of contract affecting their profits. That's direct. Driver was injured in a car accident. That's direct. So everything else was direct. It should have been an easy one. And I think most of you got that right. 16, for a $25,000 state law breach of contract claim between two Alabama residents, where can it be filed and why? Well, state law means no federal question. 25,000 means no federal court diversity jurisdiction, so it can only be in state court. And state is 25,000, which exceeds $20,000 district court, so it can only be filed in Alabama State Circuit Court. 17, an alternate dispute resolution. What distinguishes arbitration from mediation in a typical business contract dispute? And the answer is arbitration results in a binding decision, generally by a neutral third party, while mediation generally facilitates a voluntary agreement. Generally, for mediation, both parties have to agree. The mediator's job is, a lot of people say it's a compromiser. It's not really a compromiser, but it's kind of like that. 18, if the U.S. is sued in federal court, fails to answer after 50 days, what's the judge's obligation? Well, he may issue a default after 60 days, but only if no extension is requested and granted. Everything else there is wrong. 19, a lawsuit for $4,000 in unpaid rent between Alabama residents. Which court has proper jurisdiction and is a jury available? I tell you, I dictated my exam this time, and I've seen more typos as a result of dictating it. And that just means I need to proofread a lot better. A lawsuit for $4,000 in unpaid rent. What court has proper jurisdiction? Only the state district court, small claims division, which has no jury. That's it. No jury is available. Question 20 was the mandatory affirmation. Guys, I'm serious about this. I have one student that I'm looking at right now, and we've got a concern. Do not use artificial intelligence. You're cheating yourself if you do that, and there are some indicia that our algorithms can actually target. I don't want to have anybody expelled from the class. I don't want to have a recommendation that you get expelled from the university, but I will do it, and will not hesitate to do that in the appropriate case. I am going to require you to do this on every single exam. I'll usually throw in a couple points, so it should be an easy 2 points for you. But you're also making a sworn affirmation when you do that. So we'll make sure that you follow that instructions. Okay. All right. Let me see. Let me stop the sharing for a minute because I'm sitting here digging through my documents. Let me pull up okay, I'll share it now again. Okay, the exam from yesterday. By the way, I used to tell people when I went to college, I had a bathtub type memory. And they said, what do you mean by that? And I said, well, I would study something for an exam. It'd be like filling up a bathtub. And then as soon as the exam was over, I'd pull the plug and everything I learned went right down the bathtub drain. I'm not going to let you do that because I may put questions from any exam you've covered on any future exam. That's just the way it is. It's comprehensive. I want you to really understand law by the time the semester is over. and have a good feel for at least a good base of law. I don't want you to forget this stuff. Okay. Exam yesterday. Comparative negligence jurisdiction and contributory negligence jurisdictions generally come to the same conclusion if the plaintiff is partially at fault, but the defendant is more at fault. And that's false. In a contributory negligence jurisdiction, such as Alabama, if the plaintiff is any at fault, then you lose. In a comparative negligence jurisdiction, if the plaintiff is partially at fault, but the defendant is more at fault, the plaintiff wins. So completely false, bad answer to suggest anything else. It is false. Two, Stella Beck's burn covered approximately 16% of her body, including partial thickness injuries requiring no medical intervention beyond initial treatment. Well, it required a lot of medical intervention between initial treatment. She was hospitalized for 8 days, had 3 surgeries. If you ever take a look at the documentary Hot Coffee, they actually have some photographs of her inner thighs, and it is gross and disgusting unless you're a medical person and can tolerate that kind of thing. It is really sickening to see just how badly that hurt this lady. Again, that's not necessarily saying she deserved to win, but I am saying that the injuries were as severe as you can imagine. 3, McDonald's internal policy required coffee to be held at 180 to 190 degrees, a temperature that their quality assurance manager admitted could cause full thickness burns in under 10 seconds. Answer there was true. A lot of people say, why did McDonald's get such a bad verdict? Well, a lot of the testimony at trial came from McDonald's themselves. They admitted a lot of stuff and had to and should have. But people ask how the trial went bad. It didn't go bad because of what the plaintiff did. Went bad because of what the defendant did and what the defendant testified to. In the trial, that jury allocated 20% fault to LeBeck, which under New Mexico's pure comparative negligence rule barred her from recovering any compensatory damages. Well, yeah, they allocated 20%, but no, it didn't bar her from recovering any compensatory damages. The answer there is false. 5, evidence presented at trial showed that McDonald's had received fewer than 100 complaints about hot coffee burns prior to LeBeck's incident, making her case an isolated event. The answer is false. It was more than 700. 6, the punitive damage award by the jury were calculated based on 1 week's worth of McDonald's national coffee sales revenue. This is just to see if you were paying attention. It was 2 days worth of coffee sales. So the answer there is false. 7, a human factors expert testified that coffee served above 135 degrees is unsafe for immediate consumption, supporting the claim that McDonald's product was defective. No, there was nothing like that. In fact, 135, 145, 155, guess what? I know I shouldn't be drinking that right now, but I'm drinking a cup of coffee at 5:25 p.m. And it's about 155 degrees, and it is fit for human consumption, I promise. Question 8, under Alabama's contributory negligence doctrine, if LeBeck had been found even 1% at fault in a similar case, she could still recover damages reduced by that percentage. The answer there is false. Comparative negligence, it would have been true, but this is contributory negligence, and so the answer there is false. Question 9, the judge's remediator reduced the punitive damages to 3 times the compensatory award, reflecting a view that the original amount was excessive. That's true. That's one of the safeguards we have in our judicial system, where the judge has the power to do that. Question 10, punitive damages are generally awarded only if the defendant's conduct is intentional or at least willful and reckless and not just negligent. That's true. That's what punitive damages require. According to the class syllabus, how many weekly lowest exam grades may be dropped? Guys, read the syllabus. As long as I have people that are missing these questions, I'm going to keep putting them on there till y'all start getting them all right. Not this question. You won't see this one next week, but you'll probably see another one. Not to mention the daggum thing's open book. If I were you, I'd have printed out some things like, gee, the syllabus. Have it printed out so you can just, okay, well, let's see. How long is it going to take me to glance through and find out, oh, here's the missed exam policy, here's the grading policy. Take you 5 seconds, 10 seconds to get that answer. Why in the world people miss this? I don't know. It's two, but you can see that from the syllabus. 12 was the mandatory affirmation, 2 free points. 13, what was the primary reason McDonald's provided for serving coffee at that temperature? Why was it challenged in court? They said that they wanted to keep it hot for takeout service or takeaway consumption. It was challenged because burn risk outweighed convenience, with prior complaints proving foreseeability. None of the others were correct. It wasn't to enhance flavor. It wasn't to comply with health regulations. It wasn't to reduce brewing costs. 14, what role did discovery play in strengthening Lebec's case against McDonald's? We've already talked about this. It uncovered over 700 prior burn complaints, demonstrating willful disregard for safety. Why were punitive damages awarded, and how was the amount initially justified by the jury? It was to punish recklessness, justified as 2 days' worth of McDonald's coffee products, to deter future bad conduct. 18, according to Mr. Cartwright's research mentioned in the case study, how's the coffee temperature at Alabama McDonald's compared to the incident in New Mexico? It was lower at 150 to 170 degrees, similar to home machines, and safer for consumption. Wouldn't know that unless you watch the video. Got to watch this, got to read the material, watch the material, do everything that we have. This is what law is about. A lot of reading in law, a lot of watching, a lot of consumption of information. 19, what post-verdict action by the judge demonstrated a safeguard against excessive jury awards? We've already discussed it. It's a remediator to reduce punitive damages. 20, Lebec's injuries included third-degree burns requiring skin grafts. What percentage of her body was affected by third-degree burns? About 6% concentrated on her inner thighs, groin, and buttocks. Now, as I understand it, about 16% of her body was burned, but about 6% was that serious third-degree, full-thickness burns that were the gross, disgusting ones that I talked about a minute ago. Question 21, how many different coffees did Mr. Cartwright test in his video test of temperatures? It was 3. I saw 6. Somebody had 20. 20? Really? Some interesting things, but it was a Black & Decker coffee, a Keurig coffee, and then McDonald's coffee itself in my video. I enjoy doing the videos. I don't mind doing the videos, but by golly, if I do the video and put it on the website, on the Canvas, you can rest assured that I think it's important enough and not just something that ought to be ignored. I had a student that after the first exam said, "Gee, they don't make bad grades, and they may have made bad grades." And we actually set up an appointment, which I'm happy to do with anybody, to review that student's exam with them. And when I started reviewing the exam with them, and I was showing them where the answer was, they told me, they said, "Well, they didn't bother to read that part." Yikes! Yikes! You'll make other bad grades if you don't read the material, I promise. All right, let me stop the share for a second and see if I can do this without sharing inappropriate information. Stop share. Okay, let me see if I can pull back. And now I want to go over at this point. We're going to review what's coming up so you can make good grades on the torts exam. Okay, let me pull this up. All right. First of all, the grades were better on the McDonald's case than they were on the court's case. It might have been a little easier exam, but I'm hoping that instead it was you're kind of getting the hang of this stuff and you're now starting to listen to me, that I mean what I say and I say what I mean when I tell you that I'm going to put things on the exam that's going to be on the exam. So, but I was pleased that the grades did go up. Okay, for the torts exam, generally you're going to need to know how to apply, know which principle you're dealing with. It's not enough to get the right answer. You're going to have to know why the answer is the right answer. So you need to know the difference between assumption of the risk and contributory negligence and comparative negligence and negligence per se, and whether those are defenses or things that a plaintiff can use with respect to helping to prove their case. Um, what kind of damages are recoverable? We just finished talking about the McDonald's case, and we had two different types of damages in there. We had compensatory damages and we had punitive damages. And we discussed in that case what was necessary in order to recover punitive damages. Now, generally, when you have just a general negligence kind of case, an accident, something that occurred due to someone's negligence or inattentive conduct or whatever, you can recover compensatory damages only. For punitive damages, a lot of people don't remember this, but make sure you remember it. Maybe on the exam, who knows, that you recover both if you can prove punitive damages, that the conduct of the defendant was intentionally bad or it was done with gross recklessness, not just mere negligence, but gross recklessness. Like somebody goes out and they get intoxicated and they're driving under the influence and they hit somebody, you can get punitive damages from that. That's not just negligence. That's intentionally bad conduct, gross negligence while they're operating the vehicle. But if you can prove that, you don't just get punitive damages, you get punitive damages and compensatory damages. Make sure you know that. What are the different kinds of intentional torts in that section? We talk about intentional infliction of emotional distress, intentional interference with contractual relations. Um, Fraud is an example of intentional torts. Just go and see the types that we're going to talk about. Um, in the fraud case, know the difference between fraud and mere puffery. This is a great car, really good gas mileage, gets great gas mileage, most comfortable car you'll ever drive. Is that fraud? Eh, go back and review the material, and you should know that before the for the next exam. One area that's very difficult for students, I continue to test on it. It is difficult. It's probably difficult for lawyers too, but I'm still going to test on it. So there you go. Is the difference between justifiable reliance and reasonable reliance as it relates to fraud. Elements of fraud are basically, and I'm not going to try to teach it here because you have material on it, and I think you've got even a separate video, but they generally are that there was an intentional misrepresentation made of a material fact with the intent to cause someone to act on that intentional misrepresentation and actual reliance by the plaintiff to their detriment. So, hey, you told me it was a 1998 um, Jeep convertible, and they only made 12 of those in the world. And it wasn't 1998. It was 2004, and they have thousands of those. So what I bought was not worth what you told me it was worth. I relied upon that to my detriment because I didn't get as valuable of a car as I thought. I can sue you for fraud if it was an intentional misrepresentation that you made to me. Well, the reliance part, where the plaintiff has to rely upon something, falls in two categories. It can either be justifiable reliance or reasonable reliance, and the jurisdictions differ. One state applies one standard, another state applies another. The basic difference, and again, I'm not trying to teach the whole thing. Please go back and review it. But the basic difference is that you may be justified in relying upon something if an agent of the company says it to you, an employee, somebody that's authorized representative, and they tell you something verbally. So if you're in a justifiable reliance jurisdiction, you might be able to successfully sue and say, hey, I was justified in listening to that, even if they put something in writing in that contract that you sign at the end that said something different. In a reasonable reliance jurisdiction, that same set of facts, agent says something to you, it was a misrepresentation, they lied to you, you relied upon it, you may have been justified in relying on it, but if you're in a reasonable reliance jurisdiction, they'll say, wait a minute, it's not reasonable to rely upon what they said if there's something in writing you can look at and it says something different. So that's the difference, and I probably will throw a question or two on the exam like I usually do about fraud and the different reliance standards. Okay. Owner occupier of land. I think this is also something that is really important. And I see students that evidently don't spend the time on this. It's another one of those handouts. It's a separate kind of matter. It's important. There are different standards that you owe people depending upon why they're on your property. If somebody's on my property and I invited them there as a friend, guess what? They're not an invitee. I know it sounds like they are. Invitee means business invitee, it means you got to be there for a business purpose. Instead, somebody I invite to my property with a non-commercial purpose is a licensee. That's what they are. Hey, welcome to law. That's, forget trying to apply common sense and guess these things out, folks. You've got to read, you got to understand, you got to watch the videos and all that to learn this kind of thing. The standard is different. If I have someone, I've got a store and someone's in there and they're buying products. Now they are an invitee. They're a business invitee. What if someone is on my property without my permission? Well, then they're a trespasser. There are different duties that you owe to the different people because of why they're on your property. The highest duty of care that you owe is to the invitee, otherwise known as the business invitee. A medium duty of care is to the licensee, and there's almost no duty owed to the trespasser, but there is a duty not to intentionally injure them. So be careful about that. Go back and review that, understand that, so that you have that. Okay, think that's all that I have that I wanted to give you on the tips on the torts section. And now I'm going to pivot to the exam you got the following week. So hold on a second. Stop the share for just a second. And I'm going to pull up the consumer protection law. And I kind of like the way that I'm doing it this way for a couple of reasons. One is that I'm hoping that if I spread these out every couple of weeks rather than pounding you every single week, you won't get quite as sick of me and I'll get better attendance. You don't have to ask any questions. I'm happy to see the people that are here. You don't have to ask questions, but I know that if there's something that pops up and you want to ask a question, you can. So I like that. And then the second reason is you can kind of starting to get a sense of how this law thing builds on itself. You saw in torts how it built on material we learned from the McDonald's case. Well, now we're going to build on the torts test that you've got next week with the following week on consumer protection. And you're also going to see how consumer protection involves some courts type things too. Uh, Generally, last week we talked about torts. This current one you're reviewing for the next exam is torts, and some of consumer protection laws relate to torts or tort type of events, such as fraud, puffery, bait and switch, the Telephone Consumer Protection Act, also known as the Junk Fax Act. Generally, consumer protection law falls in this category that you look at state law, you look at federal law, whichever law gives you the consumer the best protection, that's the law you apply. In Alabama, that just happens to be, in most cases, it happens to be federal law. So that's why I'm going to focus on federal law for us. So you're going to need to know these things like fraud, puffery, bait and switch, Telephone Consumer Protection Act, things like what does it apply to? How does it apply? What do you have to prove? What damages can be recovered? Et cetera, those kind of things. The Fair Debt Collection Practices Act. I'm a stickler on this one. I'll tell you when I say I'm a stickler in two ways. Number one is you've got to know this law inside and out. It is a very common law that you will see violated. Very common. Probably has happened to you or somebody you know. So for that reason, I want you to know. I'm also a stickler in in knowing that because it came near and dear to my heart. I've been fortunate enough to have been successful in a number of class action lawsuits in my career. And the very first one involved a Fair Debt Collection Practices Act case. Judge Roy Moore was the presiding judge in Etowah County in Gadsden, and we got a good result from that. And as a result, I'm always had kind of a soft spot in my heart for it. And as a result, you're going to hear about this, and you're going to be tested on it as well. Fair Debt Collection Practice Act. It's going to be something that you're going to need to really pay attention to detail. You have to go through, and you'll hear some bad conduct in my fact patterns. I may give you some bad facts. Oh, this collection agency did this and that and whatever. But it still might not be a violation of the Fair Debt Collection Practices Act because it hasn't met all the elements. And that's what law is about, meeting all the elements. You have to look at the statute, apply it, make sure that everything fits. Well, let's see, they're doing this, but maybe they're collecting on a business debt. Well, guess what? It only applies to consumer debts, not to business debts. Duh. Well, I can't do anything there. Maybe the person or company doing the bad actions, maybe the ones that are doing the collection, maybe that's the person that the consumer owes the money to. Um, Acme retail department store has a credit line and a credit card they issued to their customers. One of the customers hasn't paid. Acme collection credit department calls and threatens to beat them up, threatens to report them to their employer or call their spouse or whatever. They threaten all these kind of things. Well, and maybe they're calling at 2 or 3 o'clock in the morning. Or hey, where's our money? Maybe they're banging on their door with a baseball bat. Bad conduct, but not a violation of the Fair Debt Collection Practices Act. Why? Because they're not a third party debt collector. Third party debt collector is someone other than the parties involved in the transaction. Collection agency, law firms sometimes can be third party debt collectors trying to collect a debt. So you'll need to know those things and make sure that you understand those things in order to apply that. Um, what kind of things? What if they call you at work? Do they get, are they liable the first time they call you at work? Second time? Third time? Fourth time? What's the triggering mechanism? There is some liability there somewhere, but for particular reason. What damages can you collect in the event that you can prove a Fair Debt Collection Practices Act violation? It's the federal, and all the laws we're talking about in this chapter are federal laws, except for fraud, really. Um, and the federal laws are all federal questions. So don't forget what we talked about in the courts section on exam number 1. You're going to see that kind of stuff again. Where can you file a federal Fair Debt Collection Practices Act violation lawsuit involving only $10,000? Well, you can file it in state court because state court has jurisdiction concurrently with federal court when federal court does. You can also file in federal court even though it doesn't exceed that $75,000 requirement because it doesn't have to because it's a federal question. It's a federal law. So is the Fair Credit Reporting Act violation. So is a Telephone Consumer Protection Act, Junk Fax Act. All those kind of laws are also federal questions and give rise to that kind of thing. The FTC 3-day rule. I had a former student, that called me about buying furniture in Atlanta a few years ago. And they said, I got there and just got talked into buying $6,000 worth of furniture. And I really don't want to buy $6,000 worth of furniture. It's been within 3 days. I remember something about a 3-day rule. Do I have a 3-day right of rescission? Can I get out of this contract? Well, you're going to need to tell me whether they can or not. What is that 3-day cooling off period law under the Federal Trade Commission, the FTC? The Postal Reorganization Act. If somebody mails something to you with a bill, do you have to pay? Are you required to pay? Do you have to pay if you keep the product? Do you have to return the product? What are your rights, remedies, requirements? The Fair and Accurate I can't read Transactions Act. I don't think that's what it's supposed to be. The FACTA. What does it require in terms of the credit reporting agencies? What are they obligated to give you? And how often are they obligated to give that to you? What if there is a Fair Credit Reporting Act violation? What are you entitled to? What do you have to prove in order to show that kind of thing? And the last thing, FTC remedies. A lot of the things, a lot of the violations that we've talked about, we can talk about what you might be entitled to in a court. And that's obviously what my emphasis is and where our focus is in this class for obvious reasons. But sometimes the Federal Trade Commission will get involved themselves. A, um, a company that sells tuna advertises that they are mercury free, and instead they're not mercury free, but they've got a certain percentage or whatever, and that's not correct. What kind of remedies can the FTC require the company that was making the false claims? What can they require that company to do? What kind of remedial actions can they do? Can they find them? Can they require them to take it back? I mean, how they take it back? What do they have to do with that? Um, okay. Whew. That's it. We've I guess we're 45 minutes near going on an hour. I have said an awful lot. We went over exam 1. We went over exam 2. We talked about the torts exam on the very next Wednesday, and we just concluded talking about consumer protection. At this point, number one, I'm going to remind you that this is recorded and streamed live to our class YouTube channel. But having that in mind, feel free at this point, if you have any questions or comments, or you want to ask me anything, please feel free to go ahead and do so. Remembering to limit your questions and comments and observations to things of general or public um, interest only, and not anything for you specifically, nothing personal. Certainly don't tell me anything personal on this. I'll open it up to questions now. Well, I'll ask you a question then. Was it helpful going over exams one and two? Did you see questions that you missed and now know, hey, I get why I missed those questions, and this will help me for studying for future questions? That certainly is my goal. Or did I just put everybody to sleep? Yes, I put everybody to sleep. No, I'm hoping that means yes, that it was helpful. Thank you for commenting that in the chat. I see the chat. Okay. Well, folks, thanks for being here. I appreciate it very much. I always feel I enjoy doing this more if I know people are here, because I feel like I'm actually talking to people as opposed to just recording something, which I don't like as much. So you really help me when you're here, even if you don't have any questions. But certainly, if you have questions here or at any other time, feel free to chime in. Be looking. You should have a bonus opportunity coming up pretty soon. I'm going to put that. It'll be on the announcements. It'll be on the in the quizzes section, along with every other graded activity that you ever have. So be looking for that opportunity pretty soon. Otherwise, you will have the torts exam Wednesday, and then the consumer law exam the following Wednesday. And then after that, we'll have another Zoom session for the next two sections of the class. Thanks for showing up today, and y'all have a good evening, and I will talk to y'all soon.